This courtroom is about to deliver a brutal reality check. What started as another felony case quickly turned into a deep dive into years of crime, repeated prison sentences, drug abuse, and a dangerous police chase that could have ended in tragedy. The judge is clearly frustrated, not just because of the charges, but because this defendant already had multiple chances to change course and still ended up back in court facing his 11th and 12th felony offenses. And when you hear the details of this high-speed evading arrest case, you'll understand why the courtroom atmosphere becomes so intense. The biggest question hanging over this hearing is simple: at what point does the justice system decide enough chances are enough? Stay tuned, because the judge's final comments are absolutely devastating.
I don't know. I just think it's such a. I appreciate your family being here, but it's all
bullshit
and was crazy. I mean, you could have killed people. Danger to everybody here in Jefferson County. And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health, as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Torin has an extensive criminal history. However,
here's where the courtroom battle really begins. The defense is trying to humanize the defendant by focusing on mental health struggles, physical problems, and family support. That strategy is common during sentencing because judges are allowed to consider rehabilitation potential and personal circumstances before deciding punishment. But the prosecution immediately pushes back with something much harder to ignore: a lifetime pattern of criminal behavior. They argue that prison has been the only thing stopping new crimes from happening. That's a devastating argument in any sentencing hearing because it tells the court the defendant may simply be unsafe outside incarceration. And notice something important here: prosecutors already reduced their leverage by not pursuing the habitual offender enhancement, which could have led to even harsher punishment. So now the judge has to weigh compassion against public safety. What do you think matters more in cases like this: a person's difficult background, or their repeated choices despite multiple second chances?
As he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, wait on the way.
on this.
Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for a TDC sentence in the high range on this.
So Mr.
This is the
Torrent, in
exact moment the judge stops
2019,
looking at this as just
he
another
received a
criminal
15-year
case and starts looking
sentence.
at it as a pattern that keeps repeating itself. Listen carefully to how the court breaks down the timeline: released from prison in 2023, and less than 2 years later, facing 2 more felonies. Judges pay very close attention to recidivism because it speaks directly to whether rehabilitation efforts actually worked. The court also points out something incredibly revealing. According to the substance abuse assessment, the only periods of sobriety happened while the defendant was locked up. That statement alone likely carried enormous weight during sentencing. And then comes the emotional turning point. The judge acknowledges the family support sitting in the courtroom, but essentially says support means nothing without personal accountability. That's a hard truth many families in these situations struggle with. You can feel the frustration building as the judge realizes this wasn't just reckless behavior, it was behavior that put innocent drivers at serious risk.
So you were only not, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously.
I got out one night of 23.
So you got out in 2023, and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you, as a grown man, have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. I mean, your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and you haven't it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794.
And there it is, the final ruling. The judge sentences Mr. Torrent to 20 years for attempted theft and another 20 years for evading arrest with a vehicle, with both sentences running concurrently, meaning at the same time. But the most important part of this hearing wasn't just the number of years handed down, it was the judge's reasoning. The court made it clear that this decision centered on public safety, repeated criminal conduct, parole violations, and the terrifying danger created during the chase. The judge repeatedly emphasized that this wasn't a minor evasion case. Multiple near collisions, crashing through a fence, and continuing to flee showed behavior the court believed endangered the entire community. Cases like this always raise difficult questions about addiction, rehabilitation, accountability, and how many chances someone should receive before the system prioritizes protection over rehabilitation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson County. So That being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff.
Maybe